James Mercado. I'm the president of ProVisor. I've been doing this for 25 years, and it's been a very crazy, rewarding, and challenging market as of late. So a lot of you have said, why are we doing this? Why do you do this, James? We are doing this because we want to help you as a real estate professional differentiate yourselves and bring value through your expertise, your knowledge, so you're better equipped to help and serve your clients in a very turbulent market. When you find yourselves out in the field, we want to help to empower you, educate you to make good decisions and to just differentiate yourself as a top tier professional. Today, we have a very special guest, which I'm super excited about this. Her name is Jennifer Lindsay. She's an attorney. Jennifer is also the Director of Legal Services with the WRA. Welcome, Jennifer.
Thank you. Nice to be here.
We are super happy that you're here, and being an attorney, I'm sure everybody's got a lot of questions for you today. So I want to remind the audience, we take live questions. If you have a question, just email james@provisor.com. That's my first name at ProVisor, PROVISOR.com. And we have somebody watching those questions, and they'll hand them to me, and we're going to ask Jennifer live here, all right? So we're going to just kind of just jump right in. Jennifer, what are the top 3 or 4 things that real estate agents call your office the hotline for help with?
Right now, it's about the NAR settlement that happened in March to the big class action lawsuit that's been causing a lot of volume on the hotline. Absent that, without the settlement looming out there, we get a lot of questions about whether things are material adverse facts that have to be disclosed. And we get lots of questions about negotiating after the inspection. I would say those are probably the main categories of calls we get on the hotline.
So that whole NAR settlement, there is so many opinions going around that. In a minute, which is almost impossible because I got to the Supreme Court. But in a minute, what's just the simplest way you could explain it to some of us who are maybe newer to, not me, but some people who are newer in the business that don't understand?
So there was a class action lawsuit against the National Association alleging that some of their practices were antitrust, setting prices, collusion behind the scenes. They lost that lawsuit on October 31st of 2023. And behind the scenes, they were engaged in settlement discussions with the plaintiff's attorneys. And they announced on March 15th of 2024 that they had settled the lawsuit, with the 2 big changes being the MLS offer of compensation is going away. Listing firms can still offer compensation to cooperating firms. They just can't use the MLS to do so. And the other big change is that now, before taking a buyer through a home, an agent has to have some sort of written agreement with the buyer for the home.
Okay, so if let's say maybe I'm a real estate agent and I'm just my own broker, I'm a broker owner, or maybe I work for a very small company and we're maybe having a hard time understanding all this. Is it like just normal? We can just call your office and just say, hey, help us understand this. Is that okay?
Yep. If you're members of the WRA, you have access to the legal hotline. In addition to that, we have an antitrust resource page on our website that has short videos explaining the changes. We've got FAQs. We have a legal update live that we did recently that goes over what real estate agents need to know about the settlement agreements. So
for those who maybe are not members of the WRA, what is your website?
It's just WRA.org.
Okay, so they can go there, get information, they can join.
Yep.
Highly encouraged. I've been in this business in this state for over 25 years. If you're a real estate agent, you need to be a member of the WRA. I mean, it is just prudent, wise, and it's good for your business. So as far as like after the inspection, so inspection comes through, and then it's always kind of seems like it's kind of a murky gray area here. Like, what are some of the maybe stellar problems that come up post-inspection that you see?
The biggest issue post-inspection is agents don't give themselves enough time to try to negotiate resolutions where they have the inspection done. It's often a short time frame after acceptance, 10 days, 15 days to get it all wrapped up. And ideally, if there are problems found at a property, if a buyer and a seller can negotiate some sort of resolution, whether that's asking the seller to repair or a price reduction or something along those lines, then that's great. They can negotiate a resolution by way of an amendment and move on. If they can't, then the buyer can issue what's called a notice of defects, and that potentially could kill the whole deal. So like I said, ideally, if they have enough time, they can try to negotiate a resolution by using amendments.
So question, I'm a real estate agent. I write the offer to purchase. I write in 10 days for home inspection. The home inspector gets out there on day 10 and does the inspection, gets it to my buyer. And there's a list of problems we get on day 11. What happens?
It's too late. If that deadline passes, that buyer has basically waived the inspection contingency and they are going forward defects.
Even though the inspector was there within the time frame, I didn't give my buyer, if I'm a real estate agent, I didn't give him enough time to negotiate.
Right.
So we do the inspection and then also we get that back. We have to be able to negotiate. So they have to build enough time from in that offer to get an inspector out there, go through the defects, have the discussions, get into negotiations, and 10 days seems pretty short for that.
Yeah, it's a good idea for agents to be familiar with their inspectors around town and know what their deadlines are like and typically what their volume is looking like and whether they can get out there early enough to give the buyer some time to negotiate.
If it's written in 10 days and it doesn't happen, do you find that buyers are like crying wolf and saying it's the real estate agent's fault, like you were liable, you didn't build in enough time for me? Or not really?
It's going to depend on that agent and what the discussion was. Hopefully they're educating the buyer about the importance of getting on that inspection early. That is part of the job of the agent, is to educate people as they go through the transaction to help them understand these dates and deadlines.
So we have attorney Jennifer Lindsley here with us. She is the director of legal services for the WRA. She's a smart cookie. All right. So I want to encourage you, like if you're at your office right now, tell your friends to log in and watch this. This will also be posted on our YouTube channel, so you can be able to watch it then. But we're going to be talking about a lot of tough stuff today. Jennifer, that's really good information to make sure that there's enough time built in to protect the consumer. Another question for you. What are some of the top things that are misunderstood in the listing contract?
Right now, as a result of that NAR settlement, the listing contract was just revised, and to address this notion of seller concessions, the idea of the MLS offer of compensation went away. So there was a belief that maybe sellers might start offering concessions to use for the buyer to use to pay the buyer's firm's fee. And that just discussion of concessions versus compensation to a cooperating firm is just causing a lot of confusion right now with agents. That's been a big volume of calls on the hotline, is helping people understand the difference between the seller paying the listing firm and the listing firm opening their wallet to pay a cooperating firm versus the seller opening their wallet to give money to the buyer for repairs or to pay the buyer's firm or something along those lines.
And the answer to that is you can't do that.
A seller can offer concessions. A seller can offer concessions for a buyer to use for repairs, or maybe it's an older property and they acknowledge that the carpet needs to get replaced, but they don't want to do it. They could say, we're going to offer a seller concession to give the buyer credit to replace the carpet, of course, contingent on what the lender thinks of all this money going back and forth.
Right.
It's allowed, and listing firms can still offer compensation to cooperating firms for bringing a buyer. They just can't use the MLS to advertise that. So, and because that's new, that's been causing a lot of misunderstanding in the listing contract. I think the other thing that we saw, like pre-NAR settlement, is confusion about what items are included and not included. So if a seller is offering the washer, the dryer, the stove, and the refrigerator, making sure agents understand that just putting that in the listing contract does not make it part of the deal. It needs to make its way into the offer to purchase if the buyer wants those items.
Okay, so let's talk about that. So they include all this stuff, and now all of a sudden they move in and the washer breaks the next day. Is there liability on the seller's part?
There's not in that case. There's language in the offer that says the seller is going to maintain the property and the personal property that's included in the offer through the day of closing. So if it breaks the day after closing and the seller didn't know about it, and it wasn't something like it had broken before and the seller fixed it and didn't disclose it, that's not a problem for the seller. They have to maintain the property up to occupancy, essentially, which is often the day of closing.
I've seen in some offers where when they include extra things that some real estate agents have created like an ancillary agreement where the buyer agrees to buy this stuff for $100. It's not part of the offer to purchase, but blah, blah. Is that compliant?
It is compliant. And a lot of times, if that's the situation, I'll say if it's like normal stuff, like kitchen appliances, usually that's not an issue for the lender. But if it's, a removable pier and there's canoes and there's all sorts of extra property that the seller's conveying to the buyer, oftentimes the lender doesn't want to see that in the offer to purchase because that loan is only guaranteed by the real estate, not the personal property. So they don't want to lend to fund purchase of the personal property. So if it is more than sort of the normal personal property, oftentimes that is an outside deal between the seller and the buyer. And it's sort of like a two-person garage sale where they just settle it all.
And that doesn't have to be listed on the closing disclosure, or
if it's totally outside of the transaction.
Okay,
no.
It's just a transaction of personal property per se.
Exactly. It's like a mini estate sale between those two.
That makes sense. Is there anything else that you see in the listing contracts that's confusing, or maybe that we see conflicting opinions on? I'm sure there's probably lots of things, because that's why we have lawyers, right? To interpret all this stuff for us.
I think the one other thing we see is sometimes agents misunderstand their authority under the listing contract.
Okay.
Agents have the authority to amend like the list price, if it's not selling and they want to drop the price, or the seller doesn't want to include the washer and dryer anymore. An individual agent has the authority to do that. If it's changing the commission amount, expiring out early, or shortening the term in general, that needs supervising broker's permission. So just reminding agents that that contract belongs to their firm, not the individual agent.
That's interesting to know. So the contract is part of the firm, but the specifics within listing price, the agent's empowered to make those decisions, but they can't expire a contract early without the broker signing off.
Or change the money amount.
Or change their commission amount, or even lower it?
The language of the contract says they cannot change the commission amount.
Okay.
Some firms will give unilateral authority to alter it, but they have to give that permission in writing, so the agent knows that they have the individual authority to change that.
But the way the contract sits.
Firm has to agree to it.
Got it. Okay, that's good to know. I did not know that. Thank you. So in the offer to purchase, which has been revised a few times over the years, what are a couple of things that you've noticed that are maybe misinterpreted or misunderstood, we'll say?
Okay. I think one of the big ones is buyers and sellers don't understand the earnest money process when a party breaches the contract. For example, if we're early in the transaction, the buyer has an inspection done, they've included $5,000 with their offer that the listing firm is holding, the home inspector finds defects. The buyer issues a notice of defects and gets out of the transaction. That does not determine what happens with the earnest money.
Okay.
And another example, let's say that the buyer's offer is contingent on financing. They deliver the loan commitment, so they are going forward with this. And last day, 2 days before closing, the buyer can't close, won't close, doesn't want to go forward. The seller, probably we would all agree, believes that they're entitled to the earnest money. It seems fair, right? The buyer's the one that broke the contract.
Very normal thought process.
Yeah, listing firms don't have the authority to decide what's fair. They have to wait until there's a written agreement signed by both parties to disperse that earnest money. So that part of it, when somebody's breached the contract and that earnest money is being held by the listing firm, buyers and sellers often don't understand the process, that the listing firm just doesn't have the unilateral authority to give it to whoever seems like the fair recipient.
Okay. So if there's not a mutual release sign, let's say you're buying my house and 2 days before you say, you know what, I decided that I'm joining the Peace Corps and I don't want to buy your house anymore.
Right.
And I'm thinking, well, I'm keeping your earnest money. And meanwhile, I got, Susie says, I want to buy your house. And you and I haven't agreed on what's going on with this money yet. Can I sell it to Susie?
That's a great question.
Thank you.
In that situation, without that cancellation agreement and mutual release, a real estate agent is obligated to tell the seller, you must seek legal counsel before you accept another offer as primary. So if Susie's now interested in buying your house, Susie can write a secondary offer until this one gets and sit in secondary until this gets resolved. Or Susie can write her offer contingent on this one getting resolved.
Okay.
If the seller says, I'm going to risk it all and just go ahead and accept another offer as primary before this one goes away, the real estate agent is obligated to say they can't force the seller to seek legal counsel, but they're obligated to recommend that the seller seek legal counsel. And hopefully the seller does.
Okay.
And the seller's attorney can analyze the situation and say, how likely is it that Peace Corps buyer is going to come back and try to stake a claim and say that they're the actual buyer of the property versus selling it to Susie, and help the seller analyze that risk. And the lawyer might say, go for it, accept Susie's offer. We don't think this buyer's going to come back.
So they accept Susie's offer. Buyer has an epiphany. He says, I'm not joining the Peace Corps. I want my house. I want that house. And they come back. Now you got a mess especially if you didn't talk to an attorney.
Yes.
Okay. Wow. That's tough stuff. So not yet, but we're going to talk about the financing contingency here in a little while. Just to remind you, I'm here with attorney Jennifer Lindsley. She's the director of legal services at the WRA. She's a smart cookie. She's been there 14 years. I think she started when she was 12 or something, but she is a great resource. If you're not a member of the WRA, I want to encourage you to join the WRA because her team, second to none. I've been in this business 25 years and you guys do a great job.
Thank you.
You're welcome. So in that offer to purchase, what's another hot topic that you might see?
Escalation clauses have been big over recent years.
Yeah, let's talk about that.
Do we have to?
All right. Just don't do escalation clauses.
Thank you. You heard it from him. They cause so much confusion. And there's some out there that are very well drafted. There's others where they call and they say, we've got 3 offers, 3 different escalation clauses. What's the final purchase price?
Oh my.
And you could ask each attorney on the legal team, and we might come up with a different number based on which one we think escalates first, because they're not always.
What's the intent of an escalation clause? If you're a newer agent, like what's an escalation clause? What's the intent behind it?
Escalation clauses in a competitive market? I might want to offer, $400,000 for a property, but I know there's going to be other buyers out there. I'm willing to maybe go up to 435, but I don't want to start there. So I put my offer at 400,000 and I say, I will beat the next highest offer that you receive by a certain day by $5,000 all the way up to 435. So it looks like it's a really advantageous tool to help a buyer out in a competitive market. From the seller's perspective, it looks pretty neat too, because the seller's like, great, I got these buyers competing off each other and they're gonna, ping pong up. The unfortunate thing I think about escalation clauses is that they draw all the attention and the seller's not analyzing the other terms of the offer. Is it a cash offer? That might be better than an escalated offer that's contingent on financing. Right. It does have an escalation clause, but it has radon testing and, they want to do a sewer scope and its inspection and all these other contingencies. So just helping sellers zero in on that money part is not the only part that they should be concerned about.
Okay, so what happened to multiple counteroffers?
And that's what you see. If you get a bunch of offers coming in with escalation clauses, a great tool a listing agent can use is pull out that multiple counter proposal and say, okay, you said 435, you said 425, that's your max. That's what you go up to. You all came in at 400,000. Let's counter proposal all these buyers and see how high they're really willing to go. And then we don't have to mess with escalation clauses.
Okay. Yeah, because it seems, my experience is, and I'm not a real estate agent, but my experience is it is confusing, it's murky. And when we have our clients that are in our office or we're providing the money for, they're confused sometimes when it goes around. And I just thought, if you're going to make an offer, make your best, cleanest offer that you can make. And if there's multiple offers coming in, the old school was we just did a multiple counter offer. Hey, we got 3 offers. Resubmit your best, cleanest offer. Yep. We'll let you know. But this escalation clause thing has been like the fancy widget as of late, and it seems like it's a mess.
Yes.
Okay.
Agreed.
Normal attorney? Yes, agreed. She's probably got a lot more to say than that, but we'll leave it at that today. All right. So there's obviously, you're dealing with the human factor. There's mistakes when people draft up listing contracts or, even the property condition report. What are some common mistakes that you see on that side of the business?
In terms of the offer, one of the more common mistakes, and I was kind of discussing this in the terms of the listing contract, where if the seller says, I'm offering the washer, the dryer, the refrigerator, and the stove, the buyer doesn't get that unless it's also written into the offer. And we'll get calls on the hotline that say, we just did the walkthrough, the washer's gone, the dryer's gone, the stove's gone. And we say, well, what was in the offer on the, the included in the purchase price? And the agent's like, well, nothing's there, but it was in the MLS. It was advertised. It was there when the buyer saw it. It doesn't matter. There's language in the offer that says the marketing materials don't count. The MLS doesn't count. What counts is the offer. So if the buyer wants those items, they need to include them in the offer. The seller was just offering them. They were not agreeing to sell. If they were agreeing to sell, they need to be in the offer.
So this is a question that we just had happen in my office, actually. Customer thought they were getting the big flat screen TV in the rec room because it was, mounted to the wall through this little bracket. And then on closing day, the flat screen TV was gone. The bracket was still there, but there was no TV. Could you speak to that?
Sure. In the offer and in the listing contract, it just defines fixtures. And in the definition of fixtures, it says a fixture. So fixtures are included. Fixtures are always included.
Oh, they had a bracket on the wall. That was a fixture.
Yep. In the definition, it says the definition of fixtures is audio and video mounting equipment, but not the audio and visual equipment itself.
Oh.
So the brackets do stay, but they can take the actual television.
Wow. That's important to know because this customer was pretty hot. It didn't blow up the closing because they ended up negotiating, but it was something that could have been alleviated if it would have been written in the offer. And the 84-inch flat screen OLED TV is included, not just the bracket.
Yep, and that's not intuitive to buyers and sellers. They are not going to make that distinction that the brackets stay, but the equipment can go. So it is something that agents have to have a discussion with their parties about. All
right, that's good to know. All right, so this is a live interview with attorney Jennifer Lindsley from the WRA right now. Please, if you have any questions, you can email them to james@provisor.com, and we're taking live questions. All right, Jennifer, I have some more questions.
Okay.
So when you look at the offer to purchase, it seems to me that all the bigger real estate brokers have their own addendums where they just cross stuff out, and then they have like a 17-page addendum. And then the little guys usually don't have that kind of stuff. I mean, what are some of the things that, I'm not calling names, just in general, that you see that, oh my gosh, that's just not correct, or we see problems with these addendums? Just a couple of those that you'd share with us.
Well, some are the escalation clauses that people have come up with on their own.
In the addendums that
Yep.
they've drafted, right?
Yep. And sometimes you see people trying to include like hold harmless provisions in their addendum, which is like a hold harmless provision against the agent. Like if this transaction blows up, they can't come back and sue the agent. The problem with that is that the contract is between the buyer and the seller. So that hold harmless provision is only between the buyer and the seller. They can't use the offer to purchase to bind the agents or the firm with the terms of this offer.
Okay.
Also, for consumer protection, that just doesn't look good from a licensing standpoint. Like if somebody came back and was saying, the transaction blew up, I'm going to go after my agent, and the agent tried to say, well, I snuck this hold harmless clause into the offer, I don't know that the state would look very positively on that,
Let's talk about that. So if I'm a buyer's agent and I'm representing the buyer, or I'm a seller's agent and I'm representing the seller, isn't there like a fiduciary capacity that the laws and statutes say, wait a minute, you're the agent. You're like kind of like an attorney, but they're not an attorney. We know that. But we'll talk about that relationship so the real estate agents can understand this is a little bit more serious than just slipping in a hold harmless agreement.
Right. And it is by statute. Agents have duties to all parties in a transaction, whether they're clients or customers, buyers or sellers, everybody.
Okay.
They also have extra duties that they owe to their clients. And the duties are things like fair and honest treatment. That's a duty that they owe to all parties, regardless of whether that person has signed an agreement with them, or reasonable skill and care. And the disciplining board, real estate examining board, they can fit a whole lot in reasonable skill and care if something doesn't go wrong or doesn't go well in a transaction. So there are those duties, and there's duties of confidentiality that agents owe statutorily to their parties. And there really is a huge amount of trust that consumers put in their agents, and agents should understand that, that they are being trusted to help somebody through a very complex transaction involving hundreds of thousands of dollars. And the consumer is looking to the agent to help them get through that safely and happily on the other side. So agents are great problem solvers. That's probably one of the best assets of having a real estate agent represent you in a transaction, is that they are great problem solvers because they've seen this before. And the agents that are good, they understand those duties and they care very much about their clients and making sure that they get through the transaction.
You know what? I love what you just said. That is excellent. Thank you. We just got a live question in. So the question is, from an agent perspective, there seems to be some biases towards different loan products. So if I'm a veteran and I've served this country, I'm entitled to a Veterans Administration loan, which is insured by the VA, which allows me to buy a house with no money down. And I've earned that benefit as a veteran. But what we've seen is some of the agents like, oh, we're not going to get your offer accepted as a VA loan. You have to go conventional. Well, speak to that and the ethics behind that, please.
That's interesting because VA, FHA, there are different loan programs that have different qualifications. Often condition issues can be a problem for those type of loans. So sellers, if they don't understand the loan, they might say, well, we don't want to jump through those hoops. We don't want to jump through those hoops. You have to go conventional. The way the offer to purchase is drafted, even if the buyer writes in the offer to purchase that they're going to get a conventional loan, the language of the financing commitment contingency says that the buyer can satisfy the financing commitment contingency with the loan described in the offer or any other loan acceptable to the buyer. So even if the buyer were to write conventional in the offer, if the VA is giving them a better deal, they can provide a VA loan commitment and satisfy the financing commitment contingency.
So, question, because this actually happened, the listing agent told the buyer's agent, we accepted your offer because we thought it was a conventional loan, and now all of a sudden it's a VA loan. That doesn't work for us. We would have accepted a different offer if you would have been honest and upfront with the type of loan you're doing.
The other part of that is the language in the offer says that both parties have to act with good faith and due diligence. So if a buyer was writing conventional in knowing full well that they were going to go the VA route, the seller could try to argue that they weren't acting with good faith.
Okay.
If the buyer wrote conventional in because they wanted to keep their options open and shop around and see what was the best deal for them, and they end up going for a VA, there's nothing wrong with that at all.
Okay, that's good to know. So I just want to speak to that because we are veteran advocates. We work with a lot of veterans. My company personally does. This isn't about my company today, but I know as the veteran community has that benefit attached to them, there's been a stigma or a myth that we won't accept a VA loan because VA appraisals or VA this or VA that. But we've had clients that could go conventional, but they're like, why would I go conventional if I get a lower interest rate on a VA loan and they're getting the same amount of money? Who cares? But then there's been some pushback on this. You wrote an offer as a conventional loan, not as a VA loan, because the VA has this form called an escape clause, and people freak out about that. So,
and it's the kind of thing like the buyer might not fully have understood the benefits of getting a VA loan, so they wrote conventional in there. Then they talked to a lender, found out what their options were, and they're like, "That's actually a better deal for me." I also want to warn people.
Yes,
veteran status is not a national or state protected class under fair housing. However, local communities can have additional protected classes by ordinance or by county. So there are some communities in Wisconsin where military status is a protected class.
Wow.
So if a seller or a listing firm were just outright rejecting offers based on a VA loan, they potentially are engaging in fair housing discrimination.
So if I'm a real estate agent, that's pretty serious. How do I find out if they're writing an offer in Toma,
right?
How do I find out if that's in a protected class or not?
I've
never heard this before. And I've been doing this 25 years. I did not know that.
It's in their ordinances usually. And most communities will have like a housing alliance or something like that that can help educate you about what your protected classes are in your area.
That's excellent information. Thank you so much. That's good for our veterans, and it's good for even our real estate agents to know that, because we don't need to ever be in a litigious environment. Very well said. Thank you. Okay, so speaking to that, we get into this whole situation now that I wrote the offer conventional. I find out it's a better deal for me to go VA, but the appraisal comes back and there's issues with the appraisal. I just don't want to buy the house anymore. And it comes through as a denial on the loan is denied, but it's denied VA. What is the seller's power? Like, hey, you told me you're getting a conventional, and I don't care if your VA loan's denied. I want a conventional denial. Is that legal?
Yes.
Okay.
If the buyer writes conventional in their loan or in their offer, and they show up with a VA denial, the seller can come back and say, that's not a lender rejection. So you need to get me a conventional rejection before you can get out under the financing commitment contingency.
Okay. So that's good. So the buyer has the right to shop different loan products.
Seller can push back.
The seller can push back, especially if it's denied. They can say, wait a minute here. That's not what you presented to me.
Right.
Or say with an FHA, because a lot of times people freak out on the FHA because of there's usually appraisal issues on an FHA loan. Like, we're not fixing that. It wouldn't be required on a conventional loan.
Right.
Is that true?
Right.
Seller could say, I'm not doing it.
Well, we'll talk about that. Let's say if the buyer wrote their offer FHA and they get an FHA loan and the FHA wants certain repairs made before the transaction's before they're going to issue the loan.
Which is normal.
Yep. And if the seller says, I won't do that, well, then the listing agent needs to explain to the seller, if the buyer can't get financing, if they're going to outright deny this loan, the transaction's going to not close because of that. Are you sure you don't want to replace that railway or the stairway railing down to the basement? That's all they're asking for. Right. Are you sure you don't want to put smoke detectors up? That's
right.
They're usually not outrageous fixes that they're asking for.
So then the seller, if they were deemed reasonable, they would just fix that because they knew it was an FHA. But if the offer came in conventional and they switched to FHA because let's say something happened in their credit, they got a dental collection after they were pre-approved, like we can't do conventional, but we can do an FHA. So now they're doing the FHA loan, but now they need some repairs and the offer was originally read. Does the lender or does somebody need to give notice to the seller, hey, their loan was denied conventional, but we're able to approve it on an FHA loan? Do we need to give notice to the seller on that?
No, the notice would come through by way of the buyer's loan commitment. That's often how the seller finds out that the buyer has switched loans or gone with an FHA instead of conventional.
Yeah, and if there's repairs because FHA is stricter than conventional, the seller still says, oh, it's conventional, I don't care, I ain't fixing anything. And then the real estate agent would just say, well, then their loan's not going to close.
Right.
Because it was denied conventional.
Right.
Okay, so it's just common sense then.
Yep.
Yeah. Okay, well said. Thank you. All right, so let's go to the next question because we got lots of stuff for you today, Jennifer.
Okay.
Thank you. So appraisal contingencies, all right? If that passes and there's no communication from the buyer's side, what does it actually mean regarding the appraisal and contract completion? A lot of times what we see is appraisals in busy times, they get backed up. And so the real estate agent writes a 10-day appraisal contingency and we can't get it done in 10 days because the appraiser's like, I can get out there in 14 days and no one will do extensions or let's say just falls through the crack because everybody's busy, all right? What does that mean if there's no communication from the buyer's side?
If the appraisal deadline in the offer and the appraisal contingency comes and goes and the buyer has not objected and that objection needs to be accompanied by a copy of the appraisal report,
Okay.
then the buyers essentially waive the appraisal contingency and it's off the table.
Really?
Mm-hmm.
So if my appraiser can't get out there for 14 days, my lender's appraiser can't get out there, and it says 10 days, and my real estate agent doesn't get me an extension on the appraisal contingency, is deemed satisfied?
Mm-hmm.
Wow. That's pretty serious, especially
is.
in a busy market. Oh my goodness. Okay. That's good to know. So the buyer's agent really needs to micromanage these dates. And the loan officers do too, the lenders.
And I always recommend if an agent's working with a lender that they're not familiar with, then they should reach out to the lender and say, how long do you take to deliver a loan commitment typically? How long do you guys typically take to get the appraiser out there so that the agent knows reasonable deadlines to put in the offer? We had back in 2020, when the interest rates were super low, we had offers where buyers were kind of nearly blowing past the loan commitment deadline and the appraisal deadline because the lenders were so busy, not with offers to purchase, because everyone was refinancing.
Right. Yes. Right.
And so agents needed to be in communication with their local lenders to find out how long is it taking you, so that we know what terms to put in the offer. So that should be an open communication, and especially if it's a lender that the agent's not familiar with or they haven't worked with in a while.
Okay.
Reach out, find out how long they need so that they can draft the offer appropriately.
All right. Let's take that to the next level, which is going to be, if you've been watching us, I have attorney Jennifer Lindsley here. She's with the WRA. She's the director of legal services, and she's an expert in everything what we're talking about. So we're going to talk about a very sensitive subject next called the finance contingency, because I have been doing this for 25 years and I've gotten hundreds of different interpretations on this. And I think it's been revised a few times over the years as well. But if the financing, let's start off with this, then we'll dig in a little deeper. If the finance contingency passes with no communication from the buyer side and no loan commitment delivered, what does that mean?
All right. If the deadline in the financing commitment contingency passes and the buyer has delivered nothing, no loan commitment, no lender rejection, nothing, the minute that happens and that deadline passes, the offer does not instantly become null and void. What happens is the seller gets termination rights. And it's interesting, the seller, so say the loan commitment's due on a Monday, or the financing commitment contingency is due on a Monday.
Okay.
And that Monday turns to Tuesday. The offer's still in place. It's just as soon as Monday turned to Tuesday, the seller has the ability to issue a notice of termination.
Okay.
But if the buyer can get that loan commitment still and get it in the seller's hand before the seller delivers that notice of termination, the parties are back in business, even though the loan commitment was late.
Okay.
So if the buyer reaches out to their lender on like that Wednesday, gets the loan commitment, sends it to the seller, they open it, the seller has actual receipt of that loan commitment, they're back in business, even though the buyer was late with the loan commitment.
So if the seller says, hey, I got a backup offer in the hopper right now, and they're at 12:01, boom, send on DocuSign.
Yep.
It's delivered, and that's termination, and then it's too bad, so sad for the buyer.
Buyer's out. Yep.
Even if they issue that loan commitment at 9 a.m., doesn't matter.
Right.
Okay, that's good to know. All right. Well, if those of you who maybe have an offer to purchase, we're going to start to dig into the lines around 278 to 280 right now, and of the finance contingency. And it says this: the loan commitment may contain conditions and shifts the risks to the buyer. Just speak to when it says the risk is shifted. What does that mean?
So that language in the offer is really to help the buyer understand that once they deliver that loan commitment, the protection of the financing commitment contingency is gone. And the loan commitment often is subject to conditions, whether that's employment verification, maybe the buyer's got a house they need to sell. The loan commitment is the lender saying, right now, based on what we know today, we're pretty sure we're going to lend to you, but there's other conditions you have to satisfy. And it's not a done deal until it's a done deal. So if the buyer delivers their loan commitment, let's say it was contingent on verification of employment. And I actually had somebody in my class that this happened to one time. They delivered their loan commitment and their employer got sold about 2 weeks before the transaction was supposed to close. Mm-hmm. So they didn't get a new job. They were still in the same job, but on paper, it looked like they had a new job.
Okay.
So it kicked it back and they had to go through underwriting again because on paper, it looked like something had changed.
Yes.
In that case, they were able to extend the date for closing and the transaction closed. If they weren't able to get the loan or they weren't able to extend the date for closing, that buyer would have been out of luck unless they are able to show up with cash at closing to close the deal. So delivery of a loan commitment, even if it's subject to conditions, it takes the financing commitment contingency off the table. That protection is gone.
Okay.
And if the lender ultimately doesn't fund the loan, the buyer needs to show up with cash at closing or they're going to end up in breach of contract.
Okay, so I want to talk about this. So don't listen to this part. But
Okay.
as the real estate agents know, there's a term out there called dirty loan commitments. And we get requested those. Just give me it's a dirty loan commitment. I don't care. I want something to pacify the seller. All right. So as the lender, what will happen is we'll get a loan commitment. We'll issue subject to this, and this. And then we provide that to the buyer, Jennifer. Okay. So now what happens is the liability is, you're saying not the lender, because I've been called real estate, we're going to sue you, ProVisor, or we're going to sue you, ABC Mortgage Company, because you issued the loan commitment and now it's not closing. That liability is shifted off the lender and onto
That's on the buyer.
on the buyer.
Yep. And that loan commitment, remember that loan commitment is not a guaranteed promise to lend.
It's not.
Not. It's
Okay.
saying based on what we see right now, we're pretty sure we're going to lend, but it's not an absolute pinky swear promise that the lender's going to lend. It's
Because pinky swear promises in front of the judge usually holds up.
right. That's standard of evidence.
Okay, so now the buyer, so if I'm a buyer's agent, like, and I'm the fiduciary and I'm helping them, like you said, most buyers agents do a great job and they're to the goal line, to the finish line. It should be between the lender, but also the buyers. They say, hey, listen, if you deliver this to the seller, even though these are contingencies, here's what could happen to you, Mr. and Mrs. Buyer. What could happen?
Right. If they deliver that loan commitment, financing contingency.
They meaning the buyer.
Yeah.
Right?
And so financing commitments off the table.
Okay.
And they can't close because the lender ultimately doesn't issue the loan and they don't have other resources to be able to close on this transaction. The seller could go after the earnest money. The seller could sue them for damages. One option under the offer to purchase is the seller could sue them for specific performance and try to get a court order forcing them to buy. That's pretty unrealistic if the reason they're not closing is because they couldn't get financing.
Fair. Yeah.
I don't think a court would order that. It just doesn't make sense in that situation. But yeah, it does. It shifts the responsibility onto the buyer that if they ultimately can't get the money.
Can the seller demand that they go to their lender?
The seller can request it. The seller could say, let's try to keep this together. Do you want to try my lender? Or, maybe the listing agent has experience with another lender who could turn something around quickly. They can request it, but they can't demand it.
Okay, because I thought there was language in here that talks about that they can request that the file be transferred to another lender, but they can only suggest a request, but they can't mandate it.
Right.
Okay, that's good to know.
Mm-hmm.
So just to recap, so I understand and everybody else understands, because you're the expert here, is the lender issues the loan commitment, but it's not really guaranteed because things change between now and the closing date. So as we talked off camera, it's never a deal till it's a deal.
Right.
At the end of the day. So now we give it to the buyer. So the lender's responsible not to give it to the listing agent. They give it to the buyer. Sometimes the listing agent, send me the loan commitment, send me the loan commitment. We can't do that. The lender has to send it to the buyer, and then the buyer has to understand the risks associated with that. And that's communicated by the buyer's agent.
Mm-hmm.
And we would also communicate that to them as well. And then the buyer makes that decision on the risk to deliver that then to the seller.
Correct.
And the lender is not liable.
It wasn't a promise to lend.
Okay, but the buyer is on the hook. And if they can't close, then they are opening themselves up to litigation, potential litigation. Okay.
Yeah. So everyone tells the buyer, once you get the loan commitment, you don't go buy a new car, you don't finance anything, don't touch anything to do with your credit,
Right.
Just sit still until closing.
And we need the real estate agents to remind the clients, because literally every email correspondence, email signatures, we tell them, don't do this. These are the 10 commandments of what not to
Right.
do. And then they say, oh yeah, I needed new furniture. So there's a sale at, ABC company and it was 0% interest. So I bought all this and thinking, oh my gosh, or I just bought a new Cadillac Escalade and the payment's $900 a month and now I don't qualify for a house.
Right.
So we have to work together as real estate agents and lenders to make sure that the buyer doesn't do anything like that. Okay, but it's the buyer's responsibility to deliver that loan commitment to the seller, and it's not the lender's responsibility to deliver it.
Right. And
We deliver it to the buyer.
you deliver it to the buyer. And in fact, there's language in the offer that says delivery of a loan commitment from the lender does not satisfy the financing commitment contingency. It must pass through the buyer's hands. And the buyer either has to sign it or send written direction to deliver it. So it's because the goal for having them sign it or send written direction to deliver it is to make the buyer understand the finality of that and that they are taking financing off the table.
Got it. Okay, so it's a pretty serious part of the transaction.
Yep.
To be honest.
There's no turning back after
Okay,
that.
right. If I'm a seller or I'm a listing agent, that might be a little unsettling to hear right now, right?
Right.
Like, what do I tell my sellers? Yeah, you got a loan commitment, but pack, but don't quite pack. Like, when do they start packing? It's kind of faith, right?
It is. Yep. It's like, as agents know, there's many things that can go sideways in a real estate transaction. But like I said before, agents are great problem solvers and figuring out ways to keep things moving along when it does go sideways.
Yeah. Okay. Yeah, we've seen some crazy things happen just the day before closing. You know, especially if like it's a volatile situation between maybe the parties that are selling the house. I've seen some strange things happen, and so that walkthrough is pretty important too, to make sure that things don't get destroyed, right?
Yep.
Okay. If let's say things were destroyed, let's say you're doing that walkthrough and there's damage because maybe the partners or the spouses hate each other and they wreck stuff. I mean, what happens with that? Can they postpone the closing, and who pays for like late rate lock extensions and all that kind of jazz?
That's also a good question. The offer doesn't totally address that. There is a section in the offer called property damage between acceptance and closing.
Okay.
And however the damage may occur, whether it's intentional or accidental, if it's 5% or less of the purchase price, the seller has to notify the buyer and the seller has to fix it and get lien waivers and everything else to provide to the buyer so the buyer knows that it was fixed. If it's more than 5% of the purchase price, they still have to notify the buyer, and the buyer at that point can get out of the transaction.
Really? I did not know that. I don't know if you guys knew that, but more than 5% the buyer could walk. So if there's a big storm and the basement floods, the buyer could walk from that deal.
If the damage is more than 5% of the purchase price.
So $400,000, if it's more than 20 grand, which probably would be, the buyer has the right to say, I don't want that house, sorry. And the seller's just out of luck. And they packed everything, they moved, it's just a mess.
It's just a mess.
Oh, my word. So it's never a deal till it's a deal.
Right.
That's the adage we've been talking about. All right. So we talked about a lot of stuff today. Just to remind you, we have Jennifer Lindsley here with the WRA. If you're not a member of the WRA, I'm not doing a commercial for them, but I kind of am, because I'm a big believer. It's important to know that we are not attorneys. The lenders are not attorneys. Real estate agents, for the most part, are not attorneys. It's important to talk to an attorney. And that's one of the resources you have is the legal hotline. Is an excellent resource to get clarification on all kinds of things like we've been talking about today. Anything, I'm sure there's lots of stuff that we didn't cover today in our limited time, but just share some stuff that maybe that I didn't talk about that you thought would be pertinent and bring value to the real estate agents that are watching us today.
I think it's important for agents to know your local lenders, know who's going to be your partner, your ally in these transactions, and make sure you keep those lines of communication open, because we all work together to get buyers and sellers through what can be pretty stressful. I think sometimes agents, because this is their job, they do it day by day. They sometimes forget how stressful it can be for the buyers and the sellers in these transactions. And the assistance that you can provide people helps them get through what can be overwhelming, complicated, and hopefully ends up in a happy transaction.
Okay. So what I've shared, and you probably deal with this, but I tell people, whether you're buying a $60,000 condo in Beloit or a $6 million house on Lake Mendota, the stress is the same for the buyers. It's just extra zeros.
Right.
So it's the agent's job is to just navigate through that, make sure that they have alignment with credible referral partners, and if not, then, it's not really a burden on the agent to make sure that, say, hey, I heard that lender stinks. You might want to go with a different lender or things like that. Is there any type of responsibility for the agent, or is that?
We always recommend, if you're going to recommend a lender or a home inspector or something, we usually recommend that you recommend 3 and then let the buyer pick, so that if the relationship doesn't go well, it's not coming back directly on the agent. The agent's like, I gave you some choices. You made your choice.
Okay. You don't have to answer this, so I'm going to give you the opportunity to invoke the Fifth Amendment.
Okay.
So what I have heard is, the WRA says we have to give 3 lenders out. Is that true?
It's a recommendation that we make.
Okay.
With that being said, I also think it's okay to say, if you're working with like a first-time home buyer and a lender who's great with first-time home buyers, hand-holding, explaining, I think it's okay for an agent to say, this lender does a lot of work with me with the first-time home buyers, or this lender is great with VA loans. I think that's totally okay to say.
Okay. Because nobody's an expert in everything.
Right.
Even real estate agents, like some are specialized in lake properties, some investment properties, some commercial, and the same with lenders. No lender is an expert in every single thing. So what we have noticed is like, some of the realtors like, well, I have to give out 3 cars because I don't want to get in trouble because that's what's recommended. But if it's a VA loan, say, listen, this guy is this lady is an expert in VA loans. Here's a couple options if you want to look into other options, but this is the one that I've worked with that I can attest to. There's nothing wrong with that.
Right.
Yeah. There's no exchange of money or anything.
Check company policy, of course, check with your firm policy, but you're absolutely right. If you know somebody and you know that they're solid in a particular area of expertise, it's okay to recommend them.
Okay. That's good to know. Thank you for sharing that with us. Well, we have been here this morning with Attorney Jennifer Lindsley with the WRA. We've talked about a lot of stuff. If you are just tuning in now, please take some time to watch the video. I learned a bunch of things. I've been doing this for 25 years. She has been a great wealth of information. I want to say thank you for coming on the show today.
Thank you for having me.
Yeah, you're so welcome. We host the show the second Wednesday of the month at 10 o'clock Central every month. And we're doing it to bring value to our referral partners and other just real estate agents in general, maybe newer real estate agents, even newer loan officers. There's a lot of good stuff that you can see our YouTube channel on. And we just want to say thank you for tuning in today. We want to thank Jennifer once again for being on our show today. And we want to tell everybody rates are shifting, so get ready because we're about to get another little mini boom in here. We think that we're going to see a lot of buyers that maybe weren't qualified before because of maybe debt to income or whatever with a little less expensive cost in the money. That's going to bring some new buyers in. So we're fully expecting this thing to get real busy again soon. So that's going to keep you busy. The phone's going to be ringing, navigating through this NAR settlement that she talked about. You know, if you have questions, please, and you're a member of the WRI, please reach out to our legal team. Don't assume. It's okay not to know. It's better to get a legal opinion on this than make a mistake, right?
Yep.
Yeah. Thank you so much, Jennifer.
Thank you.
All right. Have a good day, everybody.